there's a different interest involved here. We've obviously had a tendency, for example, in filings recently to put more of a focus on the interests of the plaintiffs and less on the interests of the defendant. But here it's a state, right, that would be suffering to the extent the complaint is allowed to go forward. And isn't the fact that we're dealing with a sovereign in this case cause perhaps the weighing to go in a different direction?
Well, thank you, Mr. Chief Justice. To begin, it's not suffering for a state to have to litigate in federal court. But I think what your question goes to, what your question goes to.
We'll hear about that shortly. But anyway.
What your question goes to is the other side's contention that because of the state-federal dynamic, this federalism dynamic, that perhaps the removal statute should be strictly construed. And I have three responses to that. First, as the chamber brief explains at pages 20 to 21, in Dart and Brewer, this court made clear that it doesn't provide any kind of a strict construction in this context. Second, to the extent that you have, it's only for jurisdiction. Not for procedural matters. And the third thing is that even if you would construe 1446B strictly, they still can't overcome the presumption. And we have this long history of courts having traditional equitable authority. And what we don't want is to assume that Congress wanted to handcuff federal courts so that they couldn't exercise equity. You need a clear command or some other really compelling statement to strip federal courts of that. And that should apply equally to removal as it does in other functional statutes of limitation.